pursue domestic mitigation measures with the aim of achieving the objectives of such contributions. This provision set forth two binding legal obligations, which must be performed by parties individually. In respect of the obligation to prepare, communicate, and maintain successive NDCs, the Court observes that this obligation is procedural in nature and constitutes an obligation of result. Therefore, the failure to prepare, communicate, and maintain successive NDCs, to account for them and to register them, would constitute a breach of the obligations set out in Article 4 of the Paris Agreement. The mere formal preparation, communication, and maintenance of successive NDCs is not sufficient to comply with the obligations under Article 4. The Court then turns to the question of whether and the extent to which the content of the NDCs is left to the discretion of each party under the scheme of the Paris Agreement. The Court considers that this question depends on the interpretation of Article 4. First, the clause in Article 4, paragraph 3, which states that each party's successive NDCs will represent a progression beyond that party's current NDCs, means that the party's NDCs must become more demanding over time. Second, a party's NDCs must reflect its highest possible ambition. While this term is not defined in the Paris Agreement, the Court considers that the level of ambition to be reflected in a party's NDCs has not been left entirely to the discretion of the parties. The provision reveals that the content of a party's NDCs must be capable of making an adequate contribution to the achievement of the temperature goal. In light of the above, the Court considers that the discretion of parties in the preparation of their NDCs is limited. As such, in the exercise of their discretion, parties are obliged to exercise due diligence and to ensure that their NDCs fulfill their obligations under the Paris Agreement. In the current context, because of the seriousness of the threat posed by climate change, the standard of due diligence to be applied in preparing NDCs is stringent. This means that each party has to do its utmost to ensure that the NDCs it puts forward represent its highest possible ambition in order to realize the objectives of the agreement. The obligation to prepare and communicate NDCs applies to all parties. However, consistent with the varying character of due diligence and the practice of common but differentiated responsibilities and respective capabilities, the standard to be applied when assessing the NDCs of different parties will vary, depending inter alia on historical contributions to cumulative GHG emissions and the level of development and national circumstances of the party in question. In light of the foregoing, the Court concludes that rather than being entirely discretionary, as some participants argued, NDCs must satisfy certain standards under the Paris Agreement. All NDCs prepared, communicated, and maintained by parties under the Paris Agreement must, when taken together, be capable of realizing the objectives of the agreement which are set out in Article 2. The court turns next to the obligation contained in the second sentence of Article 4, Paragraph 2, which concerns the implementation of NDCs and domestic mitigation measures. The court underlines that the obligation for parties to pursue domestic mitigation measures is substantive in nature and creates individual obligations for each party to the agreement. Moreover, this obligation is one of conduct and not of result. Accordingly, the parties are required to act with due diligence in taking necessary measures to achieve the objectives set out in their successive NDCs. In the present instance, the Court considers that the standard of due diligence attaching to the obligation to pursue domestic mitigation measures is stringent on account of the fact that the best available science indicates that the risks and projected adverse impacts and related loss and damage from climate change escalate with every increment of global warming. Turning to adaptation obligations under the Paris Agreement, the Court finds that specific obligations pertaining to adaptation are contained in Article 7, Paragraph 9 of the Paris Agreement. This provision imposes legally binding obligations upon the parties to undertake adaptation planning actions. The Court considers that the fulfillment of parties' adaptation obligations is to be assessed against the standard of due diligence. It is therefore incumbent upon parties to enact appropriate measures that are capable of enhancing adaptive capacity, strengthening resilience, and reducing vulnerability to climate change. In this connection, parties must use their best possible efforts in line with the best available science. Finally, the Court observes that the adaptation obligations under the Paris Agreement complement the mitigation obligations in preventing and reducing the harmful consequences of climate change. Next, the Court notes that the Paris Agreement establishes obligations of cooperation with respect to specific issue areas such as adaptation and loss and damage. As observed earlier, in respect of the obligation to cooperate under the Framework Convention, such obligations exist for states both under conventional international law, including Articles 7, 9, 12 of the Paris Agreement, and customary international law. These coexisting obligations inform each other, and in the present instance, the Court considers that the customary duty to cooperate for the protection of the environment reinforces the treaty-based cooperation obligations under the Paris Agreement. The Court notes that states are free to select the means of cooperating as long as such measures are consistent with the obligation of good faith and due diligence. The Court considers that the principal forms of cooperation prescribed by the Paris Agreement are financial assistance, technology transfers, and capacity building. For all these reasons, the Court considers that the climate change treaties establish stringent obligations upon states to ensure the protection of the climate system and other parts of the environment from anthropogenic GHG emissions. The Court then turns to the obligation of states under customary international law, relating to climate change. With regard to the duty to prevent significant harm to the environment, the Court considers that it also applies to the climate system, which is an integral and vitally important part of the environment and which must be protected for present and future generations. There are two main elements of this duty: the environmental harm to be prevented and due diligence as the required standard of conduct. For the duty to prevent to arise, there must be a risk of significant harm to the environment. This is the case either where no harm has yet been caused, but the risk of future significant harm exists, or where some harm has already been caused and there exists a risk of further significant harm. Whether an activity constitutes a risk of significant harm depends on both the probability or foreseeability of the occurrence of harm and its severity or magnitude. It should therefore be determined by, among other factors, an assessment of the risk and level of harm combined. The degree of a given risk of harm is always an important element for the application of the due diligence standard. The higher the probability and the seriousness of possible harm, the more demanding the required standard of conduct. The Court is of the view that the risk of significant harm may also be present in situations where significant harm to the environment is caused by the cumulative effect of different acts undertaken by various states and by private actors subject to their respective jurisdiction on control, even if it is difficult in such situations to identify a specific share of responsibility of any particular state. States must assess the possible cumulative effects of their acts and the planned activities under their jurisdiction or control. In the context of climate change, it is the sum of all activities that contribute to anthropogenic GHG emissions over time, not any specific emitting activity, which produces the risk of significant harm to the climate system. The risk associated with the climate change is a consequence of a combination of activities by different states, and that states need to avert the risk through a coordinated and cooperative response. The determination of significant harm to the climate system and other parts of the environment must take into account the best available science. The question whether any specific harm or risk of harm to a state constitute a relevant adverse effect of climate change must be assessed in concreto in each individual situation or case. Accordingly, the Court considers that the diffuse and multifaceted nature of various forms of conduct which contribute to anthropogenic climate change does not preclude the application of the duty to prevent significant harm to the climate system and other parts of the environment. With regard to due diligence as a required standard of conduct, the Court reaffirms that states must fulfill their duty to prevent significant harm to the environment by acting with due diligence. The following elements are particularly relevant when it comes to determining what due diligence requires from a state in a particular situation, including in the context of climate change. First, appropriate rules and measures, including but not limited to regulatory mitigation mechanisms that are designed to achieve the deep, rapid, and sustained reductions of GHG emissions that are necessary for the prevention of significant harm to the climate system, and adaptation measures. Second, the availability of and the need to acquire and analyze scientific and technological information. Third, current standards that may arise from binding and non-binding norms and that may be reflected in certain decisions of the Conference of Parties to the climate change treaties and in recommended technical norms and practices. Fourth, the capabilities of a state as reflected in the principle of common but differentiated responsibilities and respective capabilities. Fifth, scientific information regarding the probability and seriousness of possible harm, as states should not refrain from or delay taking actions of prevention in the face of scientific uncertainty. Six, the duty to exercise due diligence in preventing significant harm to the environment also required states to take certain procedural steps, including conduct of a risk assessment and environmental impact assessment and notification and consultation, which are particularly warranted when an activity significantly affects collective efforts to address harm to the climate system. Turning to the duty to cooperate for the protection of the environment, the Court recalls that it has customary character. The Court emphasizes the importance of cooperation in the context of a resource shared by a limited number of states. This applies even more to the climate system, which is a resource shared by all states. Cooperation between states is the very foundation of meaningful international efforts with respect to climate change. The duty to cooperate requires sustained and continuous forms of cooperation, of which treaties and their coordinated forms of implementation are a principal expression. While states are not required to conclude treaties, they are required to make good faith efforts to arrive at appropriate forms of collective actions. States must cooperate to achieve concrete emission reduction targets or a methodology for determining contributions of individual states, including with respect to the fulfillment of any collective temperature goal. The Court recognizes that the duty to cooperate leaves states some discretion in determining the means for regulating their GHG emissions. However, this discretion cannot serve as an excuse for states to refrain from cooperating with the required level of due diligence or to present their effort as an entirely voluntary contribution which cannot be subjected to scrutiny. The Court then turns to the relationship between obligations arising from treaties and those arising from customary international law relating to climate change. The Court recalls that the treaty rules and rules of customary international law as norms belonging to two sources of international law retain a separate existence. However, when several norms bear on a single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. The climate change treaties establish standards that may enable or facilitate the identification and application of the diligence that is due in specific instances. The Court also considers that the obligations arising from the climate change treaties, as interpreted herein, and state practice in implement them, inform the general customary obligations, just as the general customary obligations provide guidance for the interpretation of the climate change treaties. As it is difficult to determine in the abstract the extent to which the climate change treaties and their implementation practice influence the proper understanding of the relevant customary obligations and their application, the Court considers that at the present stage, compliance in full and in good faith by a state with the climate change treaties, as interpreted by the Court, suggests that this state substantially complies with the general customary duties to prevent significant environmental harm and to cooperate. This does not mean, however, that the customary obligations will be fulfilled simply by states complying with their obligations under the climate change treaties. While the treaties and customary international law inform each other, they establish independent obligations that do not necessarily overlap. It follows from the above that the customary obligation of any state, which is not the party to one or more of the climate change treaties at present, find expression, at least in part, in the general practice of states, which is in accordance with the obligations under the climate change treaties, as interpreted herein. Customary obligations are the same for all states and exist independently regardless of whether a state is a party to the climate change treaties. On this basis, the Court considers that it is possible that a non-party state which cooperate with the community of state parties to the 3 climate change treaties in a way that is equivalent to that of a state party may, in certain circumstances, be considered to fulfill its customary obligations through a practice that comports with the required conduct of states under the climate change treaties. However, if a non-party state does not cooperate in such a way, it has a full burden of demonstrating that its policies and practices are in conformity with its customary obligations. The Court then addresses the obligation of states under other environmental treaties. It examines in turn the relevant obligations in the Ozone Layer Convention, the Montreal Protocol, the Biodiversity Convention, and the Desertification Convention, and concludes that the obligations under those treaties are obligations that contribute to ensuring the protection of the climate system as a whole. The Court considers that the environmental treaties it addresses, the climate change treaties, and the relevant obligation under customary international law inform each other. State parties must therefore take their obligations under these environmental treaties into account when implementing the obligations under the climate change treaties and under customary international law, just as they must take their obligations under the climate change treaties and under custom international law into account when implementing their obligations under these environmental treaties. The Court then turns to the obligation of states under UNCLOS. The Court is of the view that anthropogenic GHG emissions may be characterized as pollution of the marine environment within the meaning of UNCLOS. The Court therefore considers that Part 12 of UNCLOS on the protection of the marine environment is applicable in the context of anthropogenic GHG emissions and is thus relevant to answering question A in the present advisory proceedings. On this basis, the Court considers the most relevant obligation of states under UNCLOS to ensure the protection of the climate system. In the view of the Court, the obligation under Article 192 of UNCLOS consists of a positive obligation to take measures to protect and preserve the marine environment and a negative obligation not to degrade it. Standard of due diligence to be applied when complying with the obligation to protect and preserve the marine environment is stringent. The Court also observes that state parties are, under Article 194, Paragraph 1 of UNCLOS, under an obligation to take all necessary measures to reduce and control pollution with the ultimate aim of preventing its occurrence altogether, although they are not required to ensure an immediate cessation of marine pollution caused by anthropogenic GHG emissions. In the view of the Court, it is not necessarily sufficient for state parties to fulfill their obligations under the Framework Convention and the Paris Agreement in order to satisfy the obligation laid down by Article 194, Paragraph 1 of UNCLOS. The Court considers that what constitutes a necessary measure within the meaning of that provision should be assessed according to objective criteria, taking into account the best available science, international rules and standards relating to climate change, and the available means and capabilities of the state concerned, including their different national circumstances. With regard to the obligation to cooperate under Article 197 of UNCLOS, the Court is of the view that it is an obligation of conduct which requires states to act with due diligence. This obligation is of a continuing nature, and it requires state parties inter alia to make ongoing efforts to formulate and elaborate rules, standards, and recommended practices and procedures. The adoption of treaties for the protection of climate system, such as the Framework Convention or the Paris Agreement, does not release state parties from this requirement under UNCLOS. The Court further considers that UNCLOS, the climate change treaties, and other relevant environment treaties, as well as the relevant obligations under custom international law, inform each other. The Court then turns to the obligation of states in relation to sea level rise and related issues. With respect to sea level rise and its implications, the Court considers that the provisions of UNCLOS do not require state parties in the context of physical changes resulting from climate change-related sea level rise to update their charts or list of geographical coordinates that show the baselines and outer limit lines of their maritime zones, once they have been duly established in conformity with the Convention. For this reason, state parties to UNCLOS are under no obligation to update such charts or list of geographical coordinates. The Court notes that several participants argued that sea level rise also poses a significant threat to the territorial integrity and thus to the very statehood of small island states. In their view, in the event of the complete loss of a state's territory and the displacement of its population, a strong presumption in favor of continued statehood should apply. In the view of the Court, once a state is established, the disappearance of one of its constituent elements would not necessarily entail the loss of its statehood. The Court then turns to the obligation of states under international human rights law. At the outset, it notes that the environment is the foundation for human life, upon which the health and well-being of both present and future generations depend. The Court thus considers that the protection of the environment is a precondition for the enjoyment of human rights. The Court notes that the adverse effects of climate change, including inter alia, the impact on the health and livelihoods of individuals through events such as sea level rise, drought, desertification, and natural disasters, may significantly impair the enjoyment of certain human rights, including the right to life. The Court considers that conditions resulting from climate change, which are likely to endanger the lives of individuals, may lead them to seek safety in another country or prevent them from returning to their own. In the view of the Court, states have obligations under the principle of non-refoulement, where there are substantial grounds for believing that there is a real risk of irreparable harm to the right to life if individuals are returned to their country of origin. The Court is also of the view that the adverse effects of climate change may significantly impair the effective enjoyment of such human rights as the right to health, the right to an adequate standard of living, which for its part encompasses access to food, water, and housing, the right to privacy, and the rights of women, children, and indigenous peoples. The Court considers that a clean, healthy, and sustainable environment is a precondition for the enjoyment of many human rights, such as the right to life, right to health, and the right to an adequate standard of living, including access to water, food, and housing. The right to a clean, healthy, and sustainable environment results from the interdependence between human rights and the protection of the environment. Consequently, insofar as state parties to human rights treaties are required to guarantee the effective enjoyment of such rights, it is difficult to see how these obligations can be fulfilled without at the same time ensuring the protection of the right to a clean, healthy, and sustainable environment as a human right. The human right to a clean, healthy, and sustainable environment is therefore inherent in the enjoyment of other human rights. the Court thus concludes that under international law, the human right to a clean, healthy, and sustainable environment is essential for the enjoyment of other human rights. With regard to the territorial scope of certain universal human rights treaties that are relevant to answering question A, the Court recalls that it has previously recognized the applicability of human rights treaties when a state exercises jurisdiction outside its territory. In the context of the present advisory proceedings, the Court need not determine the specific circumstances under which a state can be regarded as exercising its jurisdiction outside its own territory, since any such determination depends on the provisions of each treaty. The Court emphasizes in this regard that the scope of human rights treaty law and that of customary law are distinct. Taking into account the adverse effect of climate change on the enjoyment of human rights, the Court considers that the full enjoyment of human rights cannot be ensured without the protection of the climate system and other parts of the environment. In order to guarantee the effective enjoyment of human rights, states must take measures to protect the climate system and other parts of the environment. Under international human rights law, states are required to take necessary measures in this regard. The Court is of the view that international human rights law, the climate change treaties, and other relevant environmental treaties, as well as the relevant obligations under customary international law, inform each other. States must therefore take their obligations under international human rights law into account when implementing the obligations under climate change treaties and other relevant environmental treaties and under customary international law. Just as they must take their obligations under the climate change treaties and other relevant environmental treaties and under customary international law into account when implementing their human rights obligations. The Court then turns to question B. As observed earlier, the Court considers that this question concerns the legal consequences arising for states that have breached any of the obligations identified in relation to question A. In respect of question B, the Court's task is to identify in a general manner the legal framework under which the conduct of states can be assessed in order to determine whether a state or group of states is responsible for a breach of its obligations pertaining to the protection of the climate system and the remedies that are available to the injured state or states in case of such a breach. The Court observes that the participants in these proceedings are divided in their views as to whether the general rules on state responsibility apply in the context of climate change, or whether the legal consequences are solely or primarily governed by the climate change treaty framework. With regard to the question of applicability of the rules on state responsibility under question B, the Court notes that those rules do not vary with the nature of the wrongful act in question in the absence of a clearly expressed lex specialis. In order for the lex specialis maxim to apply, there must be some actual inconsistency or else a discernible intention that one provision is to exclude the other. The Court finds that the text, context, and object and purpose of the climate change treaties do not support the proposition that the parties intended to exclude the general rule on state responsibility. In particular, the Court finds no evidence in Articles 8 and 15 or in the procedural mechanisms thereunder of any discernible intention on the part of the parties to Paris Agreement to derogate from the customary international law rules on state responsibility for breaches of those treaty obligations. The Court concludes that responsibility for breaches of obligations under the climate change treaties and in relation to the loss and damage associated with the adverse effects of climate change is to be determined by applying the well-established rules on state responsibility under customary international law. The unprecedented nature and scale of harm resulting from climate change give rise to particular issues in relation to the application of the customary rules on state responsibility. Chief among these issues are questions relating to attribution and causation, which the Court addresses in turn. In considering the alleged difficulties in attributing actions or omissions to a state, the Court emphasizes at the outset that attribution is to be based on criteria determined by international law. In the Court view, the well-established rule of international law that the conduct of any organ of a state must be regarded as an act of that state is applicable in the context of climate change. Failure of a state to take appropriate action to protect the climate system from GHG emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act which is attributable to that state. The Court also emphasizes that the internationally wrongful act in question is not the emission of GHGs per se, but the breach of conventional and customary obligations identified under question A, pertaining to the protection of the climate system from significant harm resulting from anthropogenic emissions of such gases. In relation to private actors, the Court observes that the obligations it has identified under question A include the obligation of states to regulate the activities of private actors as a matter of due diligence. Therefore, attribution in this context involves attaching to a state its own actions or omissions that constitute a failure to exercise regulatory due diligence. Thus, a state may be responsible where, for example, it has failed to exercise due diligence by not taking the necessary regulatory and legislative measures to limit the quantity of emissions caused by private actors under its jurisdiction. The Court further notes that some participants submitted that it is difficult to invoke responsibility in the context of climate change, given that the wrongful conduct is cumulative in nature, involving different states over a period of time and involving a plurality of states that cause injury to a plurality of injured states. In this respect, the Court observes that while climate change is caused by cumulative GHG emissions, it is scientifically possible to determine each state's total contribution to global emissions, taking into account both historical and current emissions. What constitutes a wrongful act is not the emissions in and of themselves, but actions or omissions causing significant harm to the climate system in breach of a state's international obligations. Furthermore, with respect to the invocation of responsibility for conduct involving a plurality of states that causes injury to a plurality of states, the Court acknowledges that the fact that multiple states have contributed to climate change may indeed increase the difficulty of determining whether and to what extent an individual state's breach of an obligation identified in question A has caused significant harm to the climate system. However, the Court considers that in principle, the rules on state responsibility and the custom international law are capable of addressing a situation in which there exists a plurality of injured or responsible states. Therefore, in the climate change context, the Court considers that each injured state may separately invoke the responsibility of every state which has committed an internationally wrongful act, resulting in damage to the climate system and other parts of the environment. And where several states are responsible for the same internationally wrongful act, the responsibility of each state may be invoked in relation to that act. With regard to causation, the Court begins by observing that causation of damage is not a requirement for the determination of responsibility as such. Causation or causality is a legal concept that plays a role in determining reparation. Since reparation implies the existence of damage, causation must be established between the wrongful act of a state or group of states and particular damage suffered by the injured state, or in the case of a breach of obligation under international human rights law, by the injured individuals. In the Court's view, the fact that the damage was the result of concurrent causes is not sufficient to exempt a state from any obligation to make reparation. The existing legal standard for establishing causation, which has been developed in the jurisprudence of the Court, is capable of being applied to the establishment of causation between the internationally wrongful act of non-compliance with states' obligations to protect the climate system and the damage suffered by states as a result of such a wrongful act. The Court is of the view that the required legal standard of a sufficiently direct and certain causal nexus between alleged wrongful action or omission and the alleged damage is flexible enough to address the challenges arising in respect of the phenomenon of climate change. The Court observes that causation involves two distinct elements. First, whether a given climate event or trend can be attributed to anthropogenic climate change, and second, to what extent damage caused by climate change can be attributed to a particular state or group of states. While the second element must be established in concreto in respect of specific claims brought by states in respect of damage, in many cases, the first elements may be addressed by recourse to science. The scientific evidence adduced in these proceedings establishes that significant harm to the climate system has been caused as a result of anthropogenic GHG emissions. The Court has observed in the past, I quote, "In cases of alleged environmental damage, particular issues may arise with respect to the existence of damage and causation. The damage may be due to several concurrent causes or the state of science regarding the causal link between the wrongful act and the damage may be uncertain. These are difficulties that must be addressed as and when they arise in light of the facts of the case at hand and the evidence presented to the Court." End of quote. In light of the foregoing, the Court concludes that while the causal link between the wrongful actions or omissions of a state and the harm arising from climate change is more tenuous than in the case of local sources of pollution, this does not mean that the identification of a causal link is impossible in the climate change context. It merely means that the causal link must be established in each case through an in concreto assessment. The Court then turns to the question whether the character of certain obligations identified under question A result in any special legal consequences for states. In the present context, the Court considers that all states have a common interest in the protection of global environment commons like the atmosphere and the high seas. Consequently, states' obligations pertaining to the protection of the climate system and other parts of the environment from anthropogenic GHG emissions, in particular the obligation to prevent significant transboundary harm under customary international law, are obligations erga omnes. In the treaty context, the Court recalls that the Framework Convention and the Paris Agreement acknowledge that climate change is a common concern of humankind, requiring a global response. These treaties seek to protect the essential interests of all states in safeguarding the climate system, which benefits the international community as a whole. As such, the Court considers that the obligations of states under these treaties are obligations erga omnes partes. As a result, all state parties have a legal interest in the protection of the main mitigation obligations set forth in the climate change treaties and may invoke the responsibility of other states for failing to fulfill them. The Court then turns to the legal consequences arising from wrongful acts. The Court cannot, in the context of these advisory proceedings, specify precisely what consequences are entailed by the commission of an internationally wrongful act of breaching obligations to protect the climate system from the anthropogenic GHG emissions, since such consequences depending on the specific breach in question and on the nature of the particular harm. As a general observation, the Court notes that breaches of state obligations under question A may give rise to the entire panoply of legal consequences provided for under the law of state responsibility. The Court also notes that breaches of states' obligations do not affect the continued duty of the responsible state to perform the obligation breached. Under customary international law, a state responsible for an internationally wrongful act is under an obligation to cease that act if it is continuing, and if the breached obligation is still in force. In this context, the Court is of the view that the obligation to put an end to the wrongful act may require a state to revoke all administrative, legislative, and other measures that constitute an intentionally wrongful act of that state. The duty of cessation may also require states to employ all means at their disposal to reduce their GHG emissions and to take other measures in a manner and to the extent that ensures compliance with their obligations. Additionally, in appropriate circumstances, a responsible state could be required to offer appropriate assurances and the guarantees of non-repetition. Concerning the duty to make reparation, the appropriate nature and quantum of reparations cannot be assessed in the abstract and depends on the circumstances of a particular case. The Court observes that the remedy of restitution, which involves the re-establishment of the situation that existed before the wrongful act was committed, may prove difficult or unfeasible in the case of environmental harm, since such harm is often not easily reversible. Nevertheless, the Court considers that in the circumstances of climate change caused by emissions of GHGs, restitution may take the form of reconstructing damaged or destroyed infrastructure and restoring ecosystems and biodiversity. Whether or not these special forms of restitution are appropriate as reparation for damage suffered by states in relation to climate change is to be determined on a case-by-case basis. Such determinations cannot be made in the abstract. In the event that restitution should prove to be materially impossible, responsible states have an obligation to compensate. The Court considers that it is within the scope of this opinion to consider whether compensation could be owed for significant harm caused by climate change, if a sufficiently direct and certain causal nexus can be shown between the wrongful acts of one or more states and the resulting harm. In the climate change context, reparation in the form of compensation may be difficult to calculate, as there is usually a degree of uncertainty with respect to the exact extent of the damage caused. Finally, whether satisfaction is warranted for a violation by a state or states of obligations regarding the emission of GHGs and what form that satisfaction could take will depend on the nature and circumstances of the breach. Before concluding, the Court recalls that it has been suggested that these advisory proceedings are unlike any that have previously come before the Court. At the same time, as the Court concluded earlier, the questions put to it by the General Assembly are legal ones, and the Court, as a court of law, can do no more than address the questions put to it through and within the limits of its judicial function. This is the Court's assigned role in the international legal order. However, the questions posed by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. International law, whose authority has been invoked by the General Assembly, has an
close, guys. Well, that's a big win, Iya. Well, to inform our
economics,
viewers,
or any other. Above
he's
all,
back. So let's just
a lasting and
finish
satisfactory
this.
solution requires human will and wisdom at the individual, social, and political levels to change our habits, comforts, and current way of life in order to secure a future for ourselves and those who are yet to come. Through this opinion, the Court participates in the activities of the United Nations and the international community represented in that body with the hope that its conclusions will allow the law to inform and guide social and political action to address the ongoing climate crisis. For these reasons, the Court, 1, unanimously finds that it has jurisdiction to give the advisory opinion requested. 2, unanimously decides to comply with the request for an advisory opinion. 3, as regards question A put by the General Assembly, A, unanimously is of the opinion that the climate change treaties set forth binding obligations for state parties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. These obligations include the following. A, state parties to the United Nations Framework Convention on
abilities and hide under those climate treaties kasi nga deficient. Some may say weak yung mga climate treaty na yon. Now that the ICJ says that other laws are applicable, lalawak ang framework at basically kokonte yung tataguan ng polluters. And not only that, the court said the duty of states to cooperate is customary international law. Ibig sabihin, kumbaga, dapat matik mo tong gagawin. Hindi mo nahahanapan kung saan ka obliged, pero dapat mong gawin to put it as simply as possible. Another remarkable thing that the court said is walang territorial limit ang kanilang scope because the effects of greenhouse gas emissions has no territorial limit. Kumbaga, yung ginawa ng isang polluter sa isang bansa ay baka pwedeng makaapekto sa isang tao na nasa ibang bansa. Sinabi rin na applicable ang human rights treaties, pati ang principle ng intergenerational equity. This is what some are saying as a very historic pronouncement, empathic pronouncement na we all have the right to a good environment, basically. At Iya, I will turn to you on this kasi rinig ko kanina yung NDCs. NDCs are nationally determined contribution of states, and as the name entails, yung bansa yung magsasabi kung ano yung contribution or yung iaambag nila. So the criticism is that hindi naman ambitious yung mga NDC ng mga bansa. So now, the ICJ says states must do their best to make sure that their NDCs reflect the highest ambition. At habang sinasabi to ni Judge, nakikita kitang nagyeyehe.
Nagyeyehe and typing furiously.
Correct.
Straight back.
Ano bang ibig sabihin nito, Iya?
But I have to go back to yung emphasis na binigay ng World Court dun sa climate treatises na, okay, we say na they are not enough, na kailangan i-incorporate natin human rights frameworks, laws of the sea, pero yung emphasis na binigay and recounting yung obligations ng mga bansa under those treatises, no, yung mga parties ng UNFCCC is, for me yung basa ko dun is parang, guys, ayan na, nakalagay na dyan, no?
Parang matagal naman nang nandyan, parang gano'n.
Nandyan, pero hindi nyo ginagawa. And case in point, itong nationally determined contribution. So, itong NDCs, you basically, under the Paris Agreement, the parties, the countries are legally bound to create their climate action plans. Tapos nakalagay dito yung NDCs. Basically, ano yung target mo? Para ma-achieve nyo yung temperature goal of limiting warming to 1.5 degrees Celsius. So, sinabi ni Judge kanina, failure to prepare, communicate, and maintain NDCs to account for them and to register them would result to a breach. So basically, if hindi mo ginagawa yung kailangan mong gawin para ma-attain yung NDCs, it's already
A breach.
It's a failure on your part. And then they also targeted itong parang discretionary attitude ng mga parties na
Kung ano lang yung gusto mong gawin, yun lang yung gagawin mo.
kung ano lang gusto mong gawin, kung ano lang yung gusto mong gawin na no, they put emphasis in, hindi, kailangan highest ambition. Kasi the NDCs, we must satisfy certain standards. And itong standard na to is yung pag-attain ng temperature goal of 1.5 degrees Celsius. Anything lower than that, that's just not acceptable. That's a breach. So that, kaya, oh my God.
Kaya gumaganon-ganon ka kanina.
I was typing so furiously on my kasi that's already that's a big win.
Tapos yung isa pang inaabangan natin kanina na nakaganon tayo nung may narinig tayong breach is inaabangan natin kung ano ba yung sasabihin ng korte tungkol sa ano kung mag-breach ang tagal na rin namang nagbi-breach ng mga bansang to. So the ICJ said that failure of the state to take appropriate actions to protect climate systems may constitute an internationally wrongful act which is attributable to that state. And that wrongful act is not the emission per se, pero you're breaching your customary international obligation. But the court also said kanina yung paano mo i-establish yung causation, which can be challenging. Ano ba yung causation?
Yung causation basically ay yung link nung
ginawa nung
isang bansa, tapos yung how much damage yung na-cause nito. So, they did say na yung paghahanap ng causal link na to is difficult.
It's difficult.
It's also difficult to calculate how much compensation ba kung hindi materially possible na i-reconstruct na ng infrastructure or ibalik mo yung nasirang biodiversity, etc., etc. And also, to add to that, while they did say na yung hindi breach yung parang reducing the failure to reduce emission per se, they did specify na what may constitute as internationally wrongful acts ay yung fossil fuel consumption, subsidies, exploration, pag-grant na mining permits, etc. So, yun, at least doon, naano talaga ako doon na, okay, meron mga very specific na iniligay doon sa decision.
Again, we want to remind na hindi siya decision. It's an advisory opinion. At sabi nga ni Ross kanina, it's not legally binding like the other rulings are, but it's special. So bakit siya magiging special? So sinabi ng ICJ kanina na kapag, kunyari ikaw, you're one state and you think that you can prove that this state committed an internationally wrongful act, then pwede kang gumawa ng something to invoke your responsibility na ikaw gumawa ka ng internationally wrongful act. And isa sa mga closing statement ni Judge kanina ay sinabi niya that we hope that our conclusions will allow the law to inform and guide social and political action to address the climate crisis. Kumbaga, sinabi ng ICJ na ito na, binibigay na namin sa inyo ang opinion.
This is what you wished for.
Humayo kayo at gamitin ito ng tama. I'm getting some preliminary quotes from Senior Associate Justice Marvic Leonan of the Philippine Supreme Court is also very much adept in climate law.
And closely following
this. He says it's a good decision so far. It clarifies the interrelationships of the relevant treaties and customary law and also the general obligations of states. At yun nga, ano bang magagawa ng AO na to? So Justice Leonan says, hopefully, and I quote, hopefully, lawyers can be creative to find ways to enforce the obligations, including commitments under the NDCs et al. In local and international courts. He says, though, that he needs to study it further. Pero, kumbaga, sinabi na nga ng korte, humayo kayo at magpakarami. Gamitin nyo to sa tamang paraan.
I really like the language na kung saan tinapos ni Judge Iwasawa that the questions that the UNGA presented before the world's highest court is not these are not just legal problems. Sabi niya, they concern an existential problem of planetary proportions. So, I think after nito, babalik na naman tayo sa existential crisis on what to do with the climate
correct. Like,
crisis.
to temper hope, parang, of course, powerful countries are gonna do what powerful countries do
Right.
all the time, but at least we have a guiding star.
This
North
is a
Star.
watershed.
Wow.
Wow, watershed.
Kakanta na naman ng paraiso. But thank you for tuning in and staying with us. I'm about to hop into a press conference by the government of Vanuatu, and we promise to give you more analysis and explanations of what had just happened in the defining moment for our planet. This has been Lian Buan.
And this has been Iya Gozum.
Thank you so much for watching.
Thanks for staying up late with us.